This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with Ms. Brady, Mr. King, Ms. Higgs, and Ms. Nelson, and the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, Mr. Edson, and Mr. Edwards. We are outside the presence of the jury. Before we talk about instructions, at the end of the day yesterday, juror number 87, who is in seat number 6, inadvertently walked out of the courtroom with her juror notebook. She barely got out of the building, turned around when she realized that she had her notebook with her, and gave it to one of the security guards downstairs and conveyed that she was a juror in this case and asked that the notebook be returned to us. That security guard then immediately gave it to a sergeant in the sheriff's office, who then immediately provided it to us, and we have it back. Neither the security guard nor the sheriff, the sergeant, opened the notebook, and they treated it, in fact, like a hot potato. They couldn't get it to us fast enough, which was exactly the right attitude to have. So I wanted to share that with all of you, because that information was shared with me at the end of the night, last night, after you had all left. In terms of the instructions, the record should reflect that I emailed through my staff a third draft of the jury instructions, and it contains the changes that I said yesterday I was going to make, with a few exceptions, and I will talk to you about why I changed my mind with respect to a few things. But before I do that, I did a little research on the mercy issue, because I know we've had a lot of discussions on that, and the disagreement between the defense and the people, and the court has sided with the people, but the disagreement is as follows: that the defense wants an instruction along the lines of telling the jury that it can consider mercy in making its decisions and leaving it at that. The people have argued that it has to be based on the evidence, and my understanding of the law is that indeed it has to be based on the evidence. They can exercise mercy, but it has to be based on the evidence. It can't be in a vacuum, and it can't be without regard to the evidence. They can't ignore the evidence and just decide that they want to exercise mercy. So not only based on my understanding of the law, but also based on common sense, I have rejected the argument. I found a case yesterday, and this is not by any means the only case out there. There's authority out there that supports this position, but I thought that this was instructive. This is State versus McAnulty. It's capital M, small c, capital A, N-U-L-T-Y. This is an Oregon Supreme Court case from 2014, which is cited at 338 Pacific 3rd, 653. In this case, the defendant asked the judge to give the jury an instruction on mercy, and the defendant proposed two alternatives. The first alternative read as follows: the law recognizes and authorizes that any individual juror may base the decision to impose a sentence less than death on mercy alone. The other one read as follows: a juror is also authorized to consider feelings of mercy that flow from the evidence. the law provides that mercy alone is sufficient to support a life imprisonment verdict for any juror. And the Oregon Supreme Court spoke as follows. It said, this court has reviewed and rejected essentially the same challenge to a proposed mercy instruction. The defendant's proposed instruction would have instructed the jury that it could base its decision whether to impose the death penalty on mercy alone and for any reason whatsoever. We explained, and he was referring to a case by the name of Washington, we explained that this court has generally rejected that form of instruction because it fails to inform jurors that their decision must be based on the evidence before them. We further observed in Washington that the federal Constitution imposes a similar standard. Specifically, we noted in Washington that in California versus Brown, 479 U.S. 538, 107 Supreme Court 837, a case from 1987, the United States Supreme Court addressed whether an instruction the jurors must not be swayed by mere sympathy in the penalty phase of a capital case violated the defendant's rights under the 8th and 14th Amendments. Holding that it did not, the court emphasized that the key was not the meaning of the word sympathy, but the fact that the instruction properly cautioned the jury to base its decision only on the evidence before it. In the court's view, the instruction properly limited the jury's sentencing considerations to record evidence, and in so doing ensured the availability of meaningful judicial review. Applying those principles to the defendant's proposed mercy instructions, we concluded that the instruction would have incorrectly informed the jury that it could base its decision on mercy alone without considering other evidence in the record. The defendant's proposed instructions in this case are similarly flawed. Her first alternative instruction would have informed the jury that it could base its decision on mercy alone, although the defendant's second alternative instruction would have informed the jury that it could consider feelings of mercy that flow from the evidence. It then stated that the ultimate decision may be based on mercy alone. Thus, the instructions did not reflect a correct statement of the law. Accordingly, we conclude that the defendant's proposed mercy instructions did not correctly state the law, and the trial court did not err in refusing to give either instruction. California versus Brown also supports the proposition, just as the same proposition, just as the Oregon Supreme Court concluded. And I know that yesterday, Mr. Edwards cited California versus Brown as supporting the people's position, and just as the Supreme Court of Oregon did, I find that that's the case. So I'm standing by my rulings with respect to that issue. The other issue that I wanted to talk to you about has to do with the discussion that we had on the verdict forms. And we talked about 18-1.3-1201 yesterday, and I specifically talked about the first sentence in subsection 1A, which is the very first subsection of the statute, and which tells the trial court to conduct a separate sentencing hearing if there is a conviction of guilt on a Class 1 felony in order to determine whether the defendant should be sentenced to death or life imprisonment. But there's another provision in the statute that I think supports my the way that I have structured the verdict forms, and it is as follows. In subsection 2A, the statute reads as follows. After hearing all the evidence and arguments of the prosecuting attorney and the defendant, the jury shall deliberate and render a verdict based on the following considerations. Roman numeral 1, whether at least one aggravating factor has been proved as enumerated in subsection 5 of this section. Roman numeral 2, whether sufficient mitigating factors exist which outweigh any aggravating factor or factors found to exist. And then in Roman numeral 3 it says, based on the considerations in subparagraphs 1 and 2 of this paragraph A, whether the defendant should be sentenced to death or life imprisonment. So again, the statute specifically envisioning having the jury determine whether the sentence that is appropriate is a death sentence or whether it is a life imprisonment sentence. So I again stand by the verdict forms the way I have them. Now let me talk to you about why I changed my mind about a few of the changes that we spoke about yesterday. And some of these are not that I changed my mind as much as I realized that there was some discussion, and I thought about the discussion further, and then I decided to go in a different direction. The first one is in the instruction that starts with, in phase 3 of the sentencing hearing, there is no burden of proof. And I'll let you folks get to it so that we're all on the same page. At the end of that instruction yesterday, the sentence read as follows. The degree of certainty defined by beyond a reasonable doubt does not apply to a final sentencing verdict of life imprisonment without the possibility of parole. And Ms. Nelson didn't like that language, but in the end said, without waiving her objection, that if her choice was between having that language or not having it at all, she would opt to have it. And so I left it in there. But she had asked me to repeat a sentence that is used earlier in the instructions. And I wasn't willing to do that because I didn't think it was appropriate to just repeat something that had already been said in the instructions. And the sentence is as follows. A juror need not be convinced beyond a reasonable doubt that life imprisonment without the possibility of parole is the appropriate sentence in order to make a decision that will result in a sentence of life imprisonment without the possibility of parole. That's the last sentence of the third full paragraph of the instruction that starts with, you must now consider whether the defendant should be sentenced to life imprisonment without the possibility of parole or death on each count of murder in the first degree. After thinking about it further, I came up with one that I think is better than what I had before. I still don't think it's appropriate to just repeat the sentence that I just read, but what I changed that last sentence to is as follows. An individual juror is not required to have the degree of certainty defined by beyond a reasonable doubt before he or she may decide based on his or her individual reasoned moral judgment that a life sentence without the possibility of parole is the appropriate sentence. And I'll give the parties an opportunity to be heard on that if they wish. But let me get through the rest of the changes or differences between our discussion last night and what appears in the third draft of the instructions now. The next one, I think, is in the instruction that starts out with, there's no requirement that you explain or justify to your fellow jurors why your individual reasoned moral judgment leads you to a particular decision on a count. And you'll recall that we had a discussion last night with respect to that last sentence. And after thinking about it further, I ended up changing it a little bit. And to me, it's not a substantive change. It's a change as to form, but I like it better. It reads as follows. Ultimately, each of you must deliberate and decide for yourself the appropriate sentence based on your individual reasoned moral judgment. That's different than what we had left it at, or how we had it last night, at the end of last night, or how I had it, which was ultimately each of you must decide for yourself, based on your individual reasoned moral judgment, the appropriate sentence on each count after deliberating with your fellow jurors. I like it better the way I have it now. The next one has to do with the instruction that starts with Under Colorado law, the manner of inflicting a sentence of death is by the administration of a lethal injection. I ended up changing it again from inflicting back to enforcing. I know that the statute says inflicting, but there's no requirement that I see in the statute that I have to use that particular word. This is not a statute that's telling me how I should advise or instruct the jurors. And to me, enforcing is a clearer and better word than inflicting. So I have changed that. The other change that we talked about is in there now, and that is in the next sentence. That was at Ms. Nelson's request. I have added the sentence, "You must assume that a death sentence will be carried out if the jury determines that it is the appropriate sentence." So that change has been made. The final difference between the discussion we had yesterday and the current draft of the instructions is in the instruction that starts with, "In reaching your sentencing verdicts, you may consider all of the evidence admitted during the proceedings." And I changed a few things here, and I'll explain to you why. First of all, instead of referring to the evidence admitted during phase 2 of the sentencing hearing, I changed it to Dr. Jeffrey Metzner's testimony during phase 2 of the sentencing hearing, because there has been some distance now between phase 2 and where we are today, and that was the only evidence that was admitted in phase 2 that I remember, and if I'm wrong, I'm sure the parties will tell me, and I ask that you please tell me, that was admitted for that limited purpose. And it seems to me that this makes it clearer and it avoids any confusion. I don't know whether the jurors will remember which evidence in phase 2 was admitted for this limited purpose, but if I say it was Dr. Jeffrey Metzner's testimony that was admitted for that limited purpose, I think they clearly will remember it, and it will avoid any risk that they might be confused. So that's one thing I changed. The other thing I changed is that it used to say at the defense's request, at least at the end of last night, that at the end of that sentence and at the end of the following sentence, it used to say in support of a death sentence. So that sentence used to read, "However, the evidence admitted during phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor may not be considered as evidence in support of a death sentence." The next sentence used to read, "Additionally, the evidence admitted during the trial for the limited purpose of considering the issues raised by the defendant's plea of not guilty by reason of insanity, which you were allowed to consider in phase 2 of the sentencing hearing for the limited purpose of determining the existence or absence of any mitigating factor, may not be considered as evidence of aggravation in support of a death sentence." Let me address first that last sentence that I just read. It was really long and I think hard to follow, and so I shortened it. I don't think it needs to be as long as it was, and I think as shortened, it is still accurate in terms of just, we don't need to worry about phase 2 right now. We need to worry about them knowing how the limited purpose of the evidence for their purposes now, for the jurors' purposes now. So that was one change. And that's more of a change as to form, not substance. In terms of the change with respect to the language of in support of a death sentence, now it says may only be considered for that limited purpose. And the reason I changed it is because in support of a death sentence is a broader, more vague term, and I think could lead to confusion. So for example, when we're talking about that first sentence that I read, and it's the second sentence in the paragraph, the evidence admitted during phase 2 of the sentencing hearing, or Dr. Jeffrey Metzner's testimony during phase 2 of the sentencing hearing, which was admitted for the limited purpose of determining the existence or absence of any mitigating factor, may not be considered in support of a death sentence. Well, if it may be considered for purposes of determining the existence or absence of a mitigating factor, and the jury in their deliberations, the jurors in their deliberations are discussing the mitigation and the aggravation indirectly, that sentence could lead them to a sentence of death. That doesn't mean that they are considering the evidence for the wrong purpose or for a purpose that the court has told them that they cannot consider it, but it's in making the reasoned moral judgment, they could be weighing the evidence of aggravation and the evidence of mitigation, and they could conclude, well, this evidence shows to us that this particular mitigating factor does not exist, and that, in exchange, leads us to conclude that a death sentence is appropriate. I'm giving you as an example. And in the end, I decided that I should stick with the statute, which is, the statutory site is 16-8-107, subsection 1.5, A and B, that's small a and B. And what that statute says is that this evidence that Dr. Metzner provided in phase 2 of the sentencing hearing may only be admitted for the limited purpose of proving the existence or absence of any mitigating factor. And the legislature, when it passed 16-8-107, subsection 1.5, A and B, it did not have in mind that we would have a trifurcated proceeding. The legislature is thinking in terms of this being one single proceeding and one single deliberation at the end. And it's telling the court that it should instruct the jury that this is the only limited purpose for which the jury can consider the sentence if we have a sentencing hearing. So it seems to me I should stick with what the statute says and not change it, and especially when the change is to a broader term that I think could lead to confusion and to an inaccurate interpretation of the instruction and an inaccurate understanding of the law. So that was the reason why I changed it, and I think it's more cautious and more accurate to stick with the language of the statute. That doesn't mean that the jury doesn't get to consider that evidence. I'm not telling them that. I'm just saying, hey, this evidence was admitted for that limited purpose, and you got to continue to consider it for that limited purpose. That's all it is saying, and I think it is the most accurate way to proceed. So, having said all that, do the people want to be heard on any of the differences between last night and today that I have gone over? Mr. Orman?
We do not, Your Honor. Thank you.
All right. Does the defense want to be heard on any of the differences between last night and today?
Yes, Your Honor, just a few.
Give me just a second, please. All right, Ms. Nelson, you may proceed.
I have just a moment, Your Honor.
Yes.
With respect to the change to the language at the conclusion of the instruction on burden of proof and reasonable doubt,
Yes.
we would ask that the court insert an additional phrase in that last sentence so that it would read as follows. An individual juror is not required to have the degree of certainty defined by beyond a reasonable doubt before he or she may decide based on his or her individual reason, moral judgment, that death is not the appropriate sentence or that a life sentence without the possibility of parole is the appropriate sentence. That goes along with some of the discussions that we had last night about the fact that a juror may reject the death penalty without affirmatively choosing a life sentence.
I think that makes it more confusing, and I think it's unnecessary because I'm telling them in the earlier sentences and I repeat that multiple times throughout, that they can only choose a death sentence if they are unanimously convinced beyond a reasonable doubt that death is the appropriate sentence. What do the people have a position on this?
I find the court's analysis impeccable, and I agree with it.
I think it's just clearer to have it this way. I think it's confusing to add the phrase that you're requesting, and I think it's unnecessary. All right, what else, Ms. Nelson?
Next, with respect to the lethal injection instruction, we would maintain our position that it should track the language of the statute and state inflicting instead of enforcing. And in addition, we ask the court add the words beyond a reasonable doubt to that last sentence.
Give me just a second to get there. So you wanted to say you must assume that a death sentence will be carried out if the jury determines beyond a reasonable doubt that it is the appropriate sentence?
Yes.
I don't have a problem with that. Do the people have any problem with that?
No, Your Honor.
Okay, I will add that. In terms of the other word, I thought about it, and I just think the point is to tell them how it's going to be carried out. That's the point. And I don't know why we have to use inflict or any other word that to me is not as clear as enforcing or carrying out. I'm happy to use carry out if you want. Enforcing is fine with me. I think those are more appropriate words to describe what we're trying to convey to them, which is the method of execution. So, do you have a preference between enforcing or carrying out? Or carried out? It will be carried out. Yeah.
Between enforce and carry out, we prefer enforce, but maintain our original position about inflict.
Okay. Understood. Thank you. What else, Ms. Nelson?
With respect to the victim impact instruction, Your Honor.
Or hold on, let me get there. I don't think I changed this one from last night. I think I made I changed it based on how I said I would change it, which was pursuant to your request.
That's right. And when I reviewed it last night, just a small change.
Okay.
I think it would read better if the word do was changed to make. So you are never permitted to make a comparative judgment between the defendants and the victims versus you are never permitted to do a comparative judgment.
I agree with that. Any objection to that, Mr. Orman? It would read you are never permitted to make a comparative judgment instead of you are never permitted to do a comparative judgment.
I agree with counsel.
I do too. What else, Ms. Nelson?
We do object to the court's changes to the instruction discussing the limited purpose of the evidence that's been admitted, that was admitted on the issues of the insanity plea, Your Honor. And I think it's important under the Fifth Amendment in Colorado Constitution, Article 2, Section 18, to expressly state in the instructions that this evidence cannot be used as a reason, as evidence in support of a death sentence. We think that is, part of the court's analysis about why the court changed it, frankly, is exactly why we have maintained throughout the entire course of these proceedings that the statute's unconstitutional because under Estelle versus Smith, under Satterwhite versus Texas, as well as Powell versus Texas, because evidence and information that is derived as a result of Mr. Holmes' plea of not guilty by reason of insanity cannot be used in support of a death sentence, and we think those three cases clearly establish that proposition. And so we maintain our position and our arguments yesterday that at the conclusion of both the sentence about the evidence that was admitted at phase 2 as well as the evidence that was admitted at the trial for that limited purpose, that an additional sentence be added that states it may not be considered as evidence in support of a death sentence.
Well, we're not dealing with a situation in which the people have on their own brought in this evidence. It isn't a situation where, for example, we have a mitigating factor that the defense did not assert or did not attempt to present evidence on, and the people on their own presented evidence of the absence of that mitigating factor. And I'm not saying that that would be wrong, but I might see a concern there. This is a situation where mental health is at the center of this case, and the jury is aware that this is a possible mitigating factor. And so let's use mental health as an example. And I have no idea what the jury will decide or how the jury will assess this evidence. But let's assume in a hypothetical scenario that mental health is the only mitigating factor involved. And let's assume that the jury goes back to deliberate and they're trying to determine whether the appropriate sentence is life or death. And they're assessing the strength of the mitigator as part of their deliberation. And they're making comparisons and they're weighing and they're trying to figure out what their reasoned moral judgment tells them to do. And let's say they're looking at the mental health evidence, and let's say that they take Dr. Metzner's testimony in phase 2, and they decide, you know what, based on what Dr. Metzner said, we don't think that mental health is really much of a mitigator here or a mitigator at all. This is a hypothetical. In that situation, let's say the jury that says, based on that, all we have here really is aggravation, and our reasoned moral judgment tells us, after looking at everything, that this should be a death sentence. In that case, has the jury considered the evidence related to Dr. Metzner's testimony in support, and I'm doing air quotes, in support of a death penalty? Well, that's where the confusion lies. I don't know what that means, and I don't know what the jury will take that to mean. I think arguably, indirectly, that may be in support of their final decision, but that's not unconstitutional or improper because this is an issue that was raised by the defense, and the statute says the people are entitled, or the jury is entitled to consider it only for the limited purpose of determining the existence or absence of a mitigating factor. And I think the best way to proceed is to be that specific, to be that exact, and to be that clear, because otherwise I think there could be confusion, and that's what I'm trying to avoid. I think the statute says that, I know the statute says it has to be considered only for that limited purpose, and that's how the jury should be instructed. And I think that's how I should instruct the jury. That's how I instructed them when the evidence came in, and I think that's how I should instruct them now. And if this was a one proceeding only and it had not been broken down into 3 separate proceedings, that's exactly how the legislature apparently envisioned that the jury would be instructed. So I think that the most accurate and the most precise way of instructing the jury, and the way that is most consistent with the statute, that honors the statute the best, is the way that it appears in this draft. Do the people have anything on this?
I agree with Your Honor.
All right, anything else, Ms. Nelson, with respect to this instruction? No. Ms. Nelson, do you have anything else with respect to any other issues that we need to talk about at this time?
I do have 3 more things, Your Honor. In the last instruction, and this is the instruction that describes the verdict form.
Yes.
And how to complete the verdict form. In the paragraph that describes how to complete section 3, the word cannot still appears. So it says the foreperson should sign on the designated line in section 3 of this verdict form to indicate that the jury cannot reach a unanimous final sentencing verdict on that count. And as we discussed yesterday, I have a concern about the word cannot.
So do you want me to say does not or did not?
Or perhaps, and well, so this, I also have a proposed change to the language of the third section of the verdict form. So maybe we should talk about that, and then if the court agrees with that change, we can change it to be
Okay.
consistent with that. And I know that this, I appreciate the court changed this at my request, and this was language I proposed on the fly after the court had rejected my initial proposal, and I gave it some more thought last night. And I would like to propose instead, we, the jury, are not in unanimous agreement on the sentencing verdict for this count, or on the final sentencing verdict for this count.
I like to not have a unanimous final sentencing verdict on this count better.
The reason I'm proposing this new language is because I still have a concern that do not have a unanimous final sentencing verdict on this count, again, implies in some way, maybe less so than cannot, but still implies that, you know, they have to try to work towards unanimity, and then if they fail to do so, then this is sort of a last resort, that they've kind of abandoned the effort to reach unanimous verdict, and we think that would be improper under Tennyson and Young, the Eighth Amendment and Colorado Constitution, Article 2, Section 20.
I like the language I have better. I don't think it implies anything improper. Obviously, I'm instructing them that they have a duty to deliberate. The point of deliberations is to try to reach a verdict. That's the point of it. That doesn't mean that they have to agree. They're being told that they don't have to agree, but they have to deliberate. And deliberations are with the idea of trying to figure out what the appropriate sentence is, whether it's life or death. That's the whole point of deliberations. Now, any of them can say, I'm going to stick with my decision, but they have to deliberate. They don't have to change their mind. And I'm telling them all that. So I don't have a concern about this language. Do the people want me to change this language as requested?
I agree with the court, Your Honor.
All right, Ms. Nelson, what else?
So, given the court's ruling on that, and without waiving our objections and without and maintaining the position that I just articulated in terms of the language, then we would ask the court to change the cannot language to the foreperson should sign on the designated line in Section 3 of this verdict form to indicate that the jury does not have a unanimous final sentencing verdict on that count.
That's fine, and that's consistent with my change on the verdict forms. I want to be clear that I don't think the change is necessary. I said that yesterday. I continue to believe that. I don't think there's anything wrong with cannot reach, and I think arguably is the better language, but I am going to change it at Ms. Nelson's request, the way that I agreed to change it yesterday. So, is there anything else we need to talk about with respect to the instructions?
Not with respect to the instructions, Your Honor.
All right. Anything we need to talk about with respect to the instructions on behalf of the people?
No, Your Honor.
Are there any other instructions that anyone wants to tender, any other requests that anyone wants to make with respect to the instructions, any other record anybody wishes to make, any other arguments related to the instructions, or any other points or issues from your tendered instructions that you would like me to consider and entertain at this time on behalf of the people?
No, Your Honor. Thank you.
On your behalf, Ms. Nelson.
Nothing additional, Your Honor. We maintain all of the arguments that we have set forth up till this point, including the arguments contained in our tendered instructions.
You're not waiving anything, but if there's anything specific that you want me to address that you think I've forgotten or that should be in the instructions and it's not, or anything that we haven't talked about, or anything that you think I should change, now is the time to tell me. That doesn't mean you're waiving anything. I understand that you've tendered instructions, but there are a lot of instructions. So if there's anything that you think should be in there and it's not, or anything that you think we need to change that we haven't talked about yet, do you have anything like that that you want to make a record about or talk about?
No, Your Honor.
Okay. All right, thank you. Should we talk about the PowerPoint presentations? Yes, Mr. Brucker saying yes. Ms. Brady, are you the one doing it? Yes, okay. All right.
There's
Yes.
one issue kind of related to the jury instructions that
Yes.
I would like to raise, just
Okay.
so we can talk about this. During Phase 1 deliberations, there were certain items of evidence that were not taken back for obvious reasons. That did not happen in Phase 2 for obvious reasons. the way these instructions are drafted and the way I understood the argument yesterday from the defense, it would not make sense to do that in phase 3. I'm not asking that that be done, but I think the court should inquire as to whether the defense is saying there's any items that should not go back to the jury, just to see if they had that position.
Ms. Nelson?
No, Your Honor, I think they all go back at this point.
Okay, they all go back except for the live ammunition, obviously. Okay, all right. We will not provide equipment to play videos or CDs, but if there's a request for that, I will let you know, just as we did before, okay? Thank you. All right. Mr. Brockler?
Your Honor, I told Ms. Brady yesterday my intention. I put it on the record with the court this morning prior to this hearing, just prior to this hearing. I provided Ms. Brady with a 8-page PDF that contains 6 slides per page, as we've done in the past. I believe that all of those slides do not only contain exhibits that were previously admitted, but that have also been used in prior PowerPoint presentations. None of them, I believe, involve any of the NGRI limited related evidence. And I guess I would just allow Ms. Brady to make any record about what she may object to. There are 2 things that don't appear in the presentation that I want to advise counsel in the court that I still intend to consider using. One is there are those poster boards that we tried to pull off in the second phase that we show off camera that have the pictures of the deceased in the theater. There's also the audio clip of the 911 call that contains some of the rapid gunfire that took place in the theater. Those are 2 things that don't appear in the presentation that I gave Ms. Brady.
All right, and just a cautionary instruction, Mr. Brockler, similar to the one I've given you before. Be careful to make sure that when you're talking about evidence that was admitted for a limited purpose, that they know that that's the only purpose that you're arguing that evidence for, or that you're being consistent with that instruction, please.
Absolutely, Your Honor, and I believe, at least with regards to the things that I've got in the presentation and I've described here, I don't believe any of that was admitted for a limited purpose, but I do take the court's admonition seriously.
All right, thank you. Ms. Brady, do you have any objections to the slides in Mr. Brockler's PowerPoint presentation?
My only concern is there are a couple photographs of the incendiary devices in the apartment, and my understanding from Ms. Nelson is that yesterday at least a conversation was started about whether the prosecution can argue that those devices in the apartment can be argued as non-statutory aggravation. So I think we need to have a ruling from the court as to whether those devices qualify as non-statutory aggravation in addition to the death of Veronica Mosier, whether that can be argued as non-statutory aggravation in light of the fact that the jury did not find that to be a statutory aggravated factor. So we would object to those 2 things being argued as non-statutory aggravation. Other than that, I do not have any additional objections to the slides he's presented.
Can I argue that, Your Honor?
Sure.
I'm going to start off with a hypothetical. Hypothetically, and I'm going to talk about the explosives issue first and then the Veronica Mosier Sullivan issue. Hypothetically, let's say the U.S. Attorney had decided to take the apartment devices as a federal charge. Obviously, there are federal laws about that. So that it was not something that we could prove. And let's say, hypothetically, that you found, for some purpose during the guilt phase, that it was not permissible under Rule 404 for some reason. And that we got to this phase of the trial, and the jury had never heard. We got to phase 3, and a jury had never heard about what the defendant had done in the apartment. I believe that we could say that is non-statutory aggravating factor evidence that the jury should be able to consider in reaching its reasoned moral judgment as to the appropriate sentence. I think if you look at the statute, this is exactly the type of evidence that should be considered. The jury has heard this evidence. The jury knows about this evidence. It goes to the defendant's moral culpability. The fact that the defendant decided to pour gasoline on his floor, pour motor oil on his floor, set up the tripwire device with the glycerin, and the potassium permanganate to play music in his apartment so that a person might come up and open the door, to divert the police from the theater so that the first response would be delayed or diminished. All of this is evidence that the jury consider, and all of it is evidence they consider without limitation, because it either comes from the apartment itself or from the statements that the defendant made to Detectives Apple and Gumbiner. That is evidence that the jury can consider in determining, in their reasoned moral judgment, what sentence the defendant should get for the murders he committed, because it is directly related to the murders that he committed. He said so in his statement to Detective Apple and Detective Gumbiner. It goes to his moral culpability. It goes to his crime. So there's no reason that the jury cannot consider that evidence. And I would note, the defendant has not requested some type of limiting instruction from the court saying, the apartment, you should keep that out of your minds, because that would be a nonsense. That would be ridiculous. And I appreciate the defense hasn't done that. So there should be no limitation on the ability of Mr. Brockler to argue that. Regarding the issue of Veronica Mosher-Sullivan, the jury did not find the presence of that statutory aggravating factor of intentionally killing a child under 12, which when you read it really means that you set out to do that. You set out to kill a child under 12. Okay, they found that the facts did not establish that. Fine. They did not find that she was not a child under 12. It's not like they said, well, we don't believe she was 6 years old. That's not what they found. And the fact that the defendant killed a 6-year-old girl is something that the jury should be able to consider in determining the appropriate sentence. Whether he set out to kill a 6-year-old girl or not, which is what the aggravating factor that Phase 1 related to, it is evidence that they should be able to consider in determining the appropriate sentence. Otherwise, we couldn't mention that. Are we supposed to just have no picture of Veronica Mosher-Sullivan up in the third phase? Is it just we're supposed to operate under a legal fiction that she was an adult? Again, that would be ridiculous. That would be ridiculous. Is Mr. Brockler supposed to be prohibited from saying, well, consider Veronica Mosher-Sullivan. Consider that she is never going to get to grow up. Consider all of the things that she is going to miss out on in life because her life was snuffed out at such a young age. Obviously, those are factors that the jury can consider and that Mr. Brockler can argue as far as a reason to impose a death sentence. And I think if you look at the statute, that's exactly the type of information that the jury should be able to rely upon. Because otherwise, Your Honor, we would need an instruction or something to the jury. You shall not consider the fact that Veronica Mosher-Sullivan was a 6-year-old girl. You should assume that she was an adult or something like that for purposes of making your decision. That would be nonsensical. No one is asking for that. So the idea that these are somehow forbidden topics for Mr. Brockler's argument is likewise nonsensical. So unless the court has any questions for me, I think that I've expressed my position.
Okay, thank you.
Make an argument?
Yes.
I'll take the issue of the incendiary devices in the apartment first. Our position is as follows. The hypothetical scenario that Mr. Orman just described is not the scenario that we have in this case. Those are not the charging decisions that the prosecution decided to make in this case. Prosecution made a decision to charge the incendiary devices as a separate count in the complaint and information, and the jury has convicted Mr. Holmes of that count, which is a non-homicide count. Mr. Holmes will be separately sentenced on that count at a later date. And so it is improper to argue that he should get the death penalty in part because of those incendiary devices in his apartment, because the Colorado statute that governs capital proceedings clearly only applies to first-degree murder. So it would violate the statute to allow them to use this count for sentencing purposes when he will also be separately sentenced on this count at a later date. In addition, the prosecution chose to allege the statutory aggravating factor of grave risk of death to another. And they also made a decision about how they wanted to present and argue that statutory aggravator to the jury during phase 1 of the sentencing proceeding. The jury found that that grave risk of death aggravator already existed. I can't think of another reason why they would make an argument about the bombs at this point other than to suggest that the situation in the apartment also presented a grave risk of death to a group of people. So that statutory aggravator, grave risk of death, was already found by the jury, and to allow them to basically argue it again in a slightly different context, we submit would constitute an impermissible doubling up of aggravators, basically re-arguing a statutory aggravator that was already established and just getting to argue it again. And we would cite the court to the case of United States versus McCullough, MC capital C-U-L-L-A-H, which is a case that has come up at least one other time in our discussions about instructions. It's a 10th Circuit case, and the site is 76 F 3rd 1087. With respect to the death of Ms. Mosier-Sullivan, the jury acquitted Mr. Holmes of this statutory aggravator under Ring versus Arizona, under Apprendi versus New Jersey, under Wolt, W-O-L-D-T versus People. That was the equivalent of an element of the offense, and the jury rejected it and found that it did not exist. So our position is that there is a double jeopardy bar from them arguing that something about the fact that she's a child and that a child died in the theater is a reason to impose the death penalty. And what that would amount to is post-acquittal fact-finding. It would violate the Fifth Amendment, the 14th Amendment, Colorado Constitution, Article 2, Section 16, 18, 20, 23, and 25. And I would cite the court to 4 cases. Smith versus Massachusetts, 543 U.S. 462 from 2005. Arizona versus Rumsey, R-U-M-S-E-Y, 467 U.S. 203, 1984. Yeager versus United States, Y-E-A-G-E-R, and that's 557 U.S. 110 from 2009. And Satizan versus Pennsylvania, S-A-T-T-A-Z-H-A-N, I may be spelling that, transposing some letters there, versus Pennsylvania, and the site is 537 U.S. 101, and that's from 2003. Obviously, Ms. Mosier-Sullivan was a child, and she was killed in this tragic event, and that fact that's not in dispute, but our position is that that's different from allowing them to affirmatively argue that as a non-statutory aggravating circumstance when the jury has already found, the legislature has made a determination about whether and how the death of a child can be considered by a jury in a capital sentencing proceeding. The jury made those considerations, did not find it beyond a reasonable doubt, and so they cannot re-argue that or anything about the fact that she is a child as a basis for imposing the death penalty. And our position is that not only would that violate double jeopardy, but it would also violate due process and the heightened reliability required by the Eighth Amendment, as well as Article 2, Section 20 of the Colorado Constitution, to allow the prosecution to rely on a fact that the jury failed to find beyond a reasonable doubt as a statutory aggravator for any other purpose, and that would undermine the reliability of these capital sentencing proceedings.
I think you're forgetting that under the Colorado death penalty statute. The way the Colorado Supreme Court has interpreted the statute, there is an eligibility phase and a selection phase. The eligibility phase is steps 1, 2, and 3, and has been described by the court. That would be phases 1 and 2 in our proceeding. But the Colorado Supreme Court in People versus Dunlap, 975 Pacific 2nd 723, Colorado Supreme Court case from 1999, made it clear that there's a heightened standard of reliability that applies to the eligibility phase, but not to the selection phase. And the court said, once you get to the selection phase, if you get to the selection phase, all evidence that's relevant is admissible and can be considered. The concern is to have the jury make a determination in the eligibility phase based on something that's not a statutory aggravating factor. And that was one of the concerns that was present in Dunlap and the court addressed. Here, we don't have to worry about it because as a result of trifurcating the proceedings, we don't have to worry about the jury making an eligibility determination based on something improper. And the reason for that is that we forced the jurors to make a determination about aggravating factors in phase 1 and gave them instructions about what they could consider. We only moved to phase 2 if they found beyond a reasonable doubt at least one aggravating factor. They found 4. And then in phase 2, they determined that whatever mitigation exists does not outweigh aggravation. And so the jury, in effect, has now concluded that the defendant is eligible for the death penalty under Colorado law. And the only question now is selection. What penalty does the jury believe is the appropriate penalty based on each individual juror's individual reason moral judgment? And in this phase, all evidence that is relevant is admissible. And the people are not limited to the statutory aggravating factors. In fact, Dunlap establishes that. The Colorado Supreme Court said, once you get to phase 3 or to step 4 in the selection phase, the jury can consider non-statutory aggravating circumstances. Now, I had included an instruction about the definition of that, and I took it out with both parties' agreement. So, and I don't think it's necessary, but the people are entitled to present that evidence. In terms of Veronica Mosher-Sullivan, number one, it's relevant, and the jury can consider it as victim impact evidence. Otherwise, I'm not sure why I allowed it yesterday. And there was testimony about that. Of course they can consider it. It would be improper for the people to tell the jury, hey, you can consider this as an aggravating factor, and I don't anticipate that the people will do that, but they can consider her death as part of the victim impact evidence, and the loss or the harm caused by the crimes, the loss to her mom and the loss to her family. That's part of the victim impact evidence the jury heard yesterday, so of course they can consider it. Now, in terms of the jury having found that this was not a proven statutory aggravating factor, what they found or what they failed to find was a statutory aggravating factor is that the defendant intentionally killed a child under the age of 12. So if Mr. Brockler were to get up in closing argument and say, and you can look at the evidence and consider that he intentionally killed a child under 12, then that would be improper. The jury has made that determination. But to say that one of the people who ended up being a victim of the defendant's acts was a child under 12, the jury can consider that. That's part of the evidence that the jury can consider from the trial. Similarly, the evidence about incendiary devices is part of the evidence the jury can consider in the selection phase. That is non-statutory aggravating circumstances evidence. Again, you have to be careful not to mix it up with statutory aggravating factors, which the jury has determined what those are. But because of the way we have proceeded in this sentencing hearing, we don't have to worry that the jury is somehow going to consider something it should not in determining that the defendant is eligible for the death penalty. That determination has been made. He is eligible pursuant to the jury's verdicts in phase 1 and phase 2. And the only question that remains in the selection phase is what sentence the jury believes is the appropriate sentence. So, I disagree with the defense, and I agree with the people on this particular point. So for those reasons, the objection to the slides is overruled. Anything else, Ms. Nelson?
Your Honor, I just want to make clear that we have a disagreement with the court that heightened standard of reliability does not apply at the selection phase of capital sentencing proceeding. It's our position that the United States Supreme Court has clearly held that it applies to the entirety of a capital sentencing proceeding.
Look at Dunlap. It says exactly that. It's the case that I cited, People versus Dunlap. It says exactly that. So, and because of the way we've handled this sentencing hearing, we've actually eliminated a lot of the risk that generally exists in these sentencing hearings, and especially in the eligibility phase. We have taken the jury through this step by step. I looked at the instructions that were used in Dunlap, and I'm not being critical of anyone, but they were confusing. They would have been even more confusing in our case because of the not guilty by reason of insanity plea and because of the limited purpose for which certain evidence could be used. In my view, it would have been impossible to do this, or at least improper to do this in one shot and to have the jury make the determination at the end. Essentially, we would be giving the jury right now instructions on everything. And we would be saying, okay, first you have to decide the question of aggravating factors, but you can only consider this evidence for that. And then if you decide X, then the sentencing hearing is over, but if you phase 2, and there you can consider this evidence, but for this limited purpose. And then you have to make this decision. And there, if you decide X, then the sentencing hearing is over, but if you decide Y, then you go on. And then you get to phase 3. And there, you get to exercise your reasonable moral judgment, and you get to decide what sentence is appropriate. But now, there's a difference in what kind of evidence you can consider. It would have been so confusing and so unfair, in my view, to the jury and to the defendant and to the people that it would have been improper. And I think we did it really the only way that we could do it under all the circumstances, especially given how long each phase has taken and how hard it would be for the jury to have to remember back to each phase and what was presented or not presented with respect to each phase. So, all right, is there anything else at this time on behalf of the people that I can address, Mr. Bruckler?
Sir, just to say I appreciate where we are with the PowerPoint. We still have several hours, I think, before we get going. I don't intend to add anything to it, but to the extent that I delete slides or move the order around, I intend to give a copy of that final presentation to Ms. Brady in advance of the instructions. But I don't anticipate anything additional that would need to be brought to the court's attention.
Okay, Ms. Nelson, anything else from you?
I do have one additional thing, Your Honor, that related to Ms. Mosier-Sullivan, and it's a motion in limine with respect to the prosecution's closing argument. We would move in limine to preclude the prosecution from using the phrase, our 6-year-old. I think that's a phrase that Mr. Brockler has used in perhaps each of his closing arguments thus far, at least one of them that I remember. Our concern is that this implies or encourages an emotional attachment to her by the jury and encourages an emotional response, and it sort of suggests that she is the community's child in some respect, or conveys a personal opinion about her and her character. Obviously, it's an incredibly sad, awful, and tragic circumstance of this case, and no one would argue otherwise. But I think that using this term, our position is that using this term, our 6-year-old, is improper for the reasons that I've stated, and we ask that he not be permitted to use that phrase in this closing argument.
Mr. Brockler, are you or Ms. Orman, are you folks intending to refer to our 6-year-old?
No, Your Honor, and we've all just had a brief conversation here. None of us remember that happening. I guess the record will be the ultimate arbiter of that, but Mr. Brockler has no intention of using that.
Okay, well, that takes care of it then. And I don't remember whether that's being used. I'm not saying, Ms. Nelson, that you're wrong. You may well be right. I don't remember that being used. And certainly no objection was made, or I think I might remember it. But in any event, there's no disagreement, and I think it's appropriate to proceed as the parties have agreed. All right, let's break then. If anything comes up that I need to address before 1 o'clock, if you would let my staff know through email, please, I would appreciate that so that we don't come here at 1 only to find out that there are additional issues that we need to talk about, okay?
Is there one more thing? Can I raise one more thing?
You bet.
I'm just sort of asking when the court would like to have me address this. I'm not necessarily asking to address it now. It's something I just want to put on the table. At some point, I would like to at least have a discussion on the record as to the court's intention regarding access to the court file regarding specific types of exhibits. And specifically, I think the Criminal Justice Records Act probably gives the court discretion regarding the criminal justice records here. And there have been some exhibits that I think the court should consider whether or not to grant the public access without some kind of special need. Specifically, and I know that the victims in this case would not want the court to give out what we have classified as the graphic photographs and the crime scene video, which would show the deceased bodies. Additionally, I would think the defendant might have a position regarding release of things like the notes from Dr. Fenton or the interview with Dr. Reed. Even though that was played on the video here, it's a different quality. And I'm not sure whether the limited waiver of confidentiality would somehow provide some protection. I don't know. I just think this is an issue that the court might want to consider and we might want to at least have a discussion on the record about, so I thought I would just bring that up as a topic of conversation.
Thank you. I've thought about that. There are obviously pretrial orders, too, that we have suppressed. There are pleadings that we have suppressed. There are bench conferences that we've had. There are exhibits that have not been made public. How about if we do it this way? How about if there is a request for access to any such pleadings or documents or exhibits? I give both of you a chance to be heard on that request before I rule on it. How does that sound?
I think that's an excellent plan, Your Honor.
All right. Is that okay with you, Ms. Nelson?
I think that's an appropriate way of dealing with it, Your Honor.
Okay, that's how we'll proceed. One other thing, I almost forgot. In the first instruction where I am giving the jurors the advisements, I added the following sentence: you should do your utmost to avoid all news reports. That's consistent with the instruction that Ms. Brady suggested, which I adopted yesterday, okay? All right. All right, folks.
Your Honor, maybe?
Yes.
I'm sorry, just one more thing, because I can see us needing to raise this at another time, and there may be lots of things going on. It may be difficult. I just wanted to understand the court's position. We're going to get a verdict here one way or the other. I mean, a verdict, a sentence from the jury. And,
Or from me.
Or from you, right.
Right.
But well, the jury's going to return a verdict form to the court.
Right.
And then the jury's job is done. My position is once that has happened, the court's order regarding limitations on pretrial publicity should no longer be in effect, because the purpose of it was so that the jury can make a decision without the impact of pretrial publicity. Obviously, if there's a sentencing hearing in the future, whatever pretrial publicity is out there is not going to affect Your Honor. So I think that if you look at Rule 3.6 and 3.8, what they contemplate is pre-verdict type of publicity and not post-verdict type of publicity. If you look at 3.6, it talks about the accused. The defendant is no longer the accused, he's the convicted. So the rationale behind the court's orders for limiting pretrial publicity to me would seem to end upon the jury returning whatever verdict form it turns in. That is my understanding of what the court's orders say, and I just wanted to see if the court has a difference of opinion on that so that we can operate accordingly and take appropriate actions.
When you say pretrial publicity, I'm not following. What are you referring to exactly?
The court, and I think it was Judge Sylvester, had entered, and I don't remember their numbers, a couple of orders limiting pretrial publicity.
You mean a gag order?
The gag order, Your Honor.
Preventing you from making public statements about the case?
Correct, Your Honor.
And you're saying once the jury returns the verdicts, or the verdict forms, you want to make sure that that no longer applies so that you can proceed accordingly, or that it does apply so that you can also proceed accordingly.
Correct.
All right. Does the defense have a position on this? All right, thank you. I believe that that order would apply up until the jury returns the verdict forms, and after I have announced whatever the contents of the verdict forms are. From there on out, then it would not have any application.
Thank you, Your Honor. And one last thing, if I may.
This is the third time you said last thing.
You know, Your Honor, I'm sitting here.
This is for real your last thing. Go ahead.
Things occur to me as I'm sitting here, and while I've been on this trial, I've sort of had to put this job aside, but one of my jobs is the records custodian for the DA's office in Arapahoe County, and I anticipate we are going to get a number of public records requests relating to this case, and I know how to exercise that discretion. The issue that I have is I know for a fact we are going to get public records requests for things like the defendant's mental health evaluations, the records that we have on these things, the discs, original copies of the original discs to Dr. Reed. I think that the defendant may have continuing confidentiality in those. And I don't want to be the one to have to make that decision sort of as an administrative official, which is what I normally do as a records custodian. When I could see someone saying, well, how are you making that decision for someone you prosecuted? So in the event, and I imagine the defense would object to me releasing such records. In the event that I get such a request, my request is that the court authorize a procedure where I can say I've received such a request and the defendant would have the opportunity for a hearing in front of Your Honor before I would give out the records that we have that I think might be subject to that confidentiality, so that the defendant would have an opportunity to have a neutral arbiter decide on that.
Ms. Brady, what do you think about that?
Your Honor, we continue to assert all confidential and privileges that Mr. Holmes has under his state and federal constitutional rights, and we do object to any release of any information that is covered by those privilege and confidentiality.
What's your position on the request to have a proceeding where you can be heard to make objections to any specific requests?
I don't have an objection to that.
All right, let's do it that way then. I haven't done any research on this, and I haven't looked at the rules or statutes that apply. So just because I'm agreeing to have some kind of proceeding, it doesn't mean that I'm agreeing that there will be a hearing, or that I'm agreeing that I get to make a decision, or that there should be something formal in front of the court. I'd have to look at the rules and the statute to see if they provide for that kind of procedure. But assuming that they do, then that's how we would proceed from there. We would have some kind of hearing, some kind of formal proceeding, and the defense could be heard to object, and then I would make determinations if it's up to me, or I'd have to see what the rules say and what the statutes say. You're probably much more familiar with them than I am, Mr. Orman, because of the position in which you've been in your office.
Your Honor, here's what I can tell you about that. There's two statutes regarding public records in Colorado. There's CORA, the Colorado Open Records Act,
Right.
which does not apply to these records. Then there's the Colorado Criminal Justice Records Act, which does. CORA actually has a procedure where if the records custodian is unsure about whether they can release records, to go in front of the judge and to say, Judge, we're not sure, you make the call for us.
Right.
CCJRA does not have such a procedure built in.
Right.
The way the CCJRA is structured is I, as the records custodian, consider a number of factors, and they're outlined in a case called Freedom Colorado, Inc. versus El Paso County Sheriff. And I consider those factors and make a decision in my discretion as to whether or not to release the records. If a media outlet or whoever is requesting the records disagrees with that, we can have a discussion, but if we don't come to an agreement, they then can file a lawsuit, and I am the defendant, where they are seeking essentially equitable relief from the court to require me to disclose those records. And it's a show cause hearing for me to show cause why not. I can do that, and I can say that I think that these records are covered by confidentiality. The problem with that is I don't think the defendant has a part in that proceeding. And I think that when we're talking about something like psychiatric records, that the person who would hold the privilege normally for those records should have a voice in it. I think that if you also look at the Criminal Justice Records Act, there's a provision in there that says I should not give out records if doing so would violate a court order. These proceedings are going to be ongoing. Regardless of whatever verdict the jury reaches in this case, at least for a while, this court is going to have continuing jurisdiction over the parties and over the case. And I think that the court has an inherent authority in exercising that jurisdiction to limit me from disclosing confidential information. And I think that the defendant should have the opportunity to challenge the potential release of such information to the public, because anybody can get it, and once they get it, it can go anywhere on the internet and so forth. I am saying this really in an attempt to protect the defendant's rights to confidentiality in the information and to give him the opportunity to do that. So that is where I see the law is, and that's why I have asked for this.
And based on that, that's why I was asking the question, because that was sort of what I thought, but I wasn't sure. I think we should follow the rules. So you got to make whatever decision you got to make based on your discretion. If somebody wants to initiate a proceeding because they disagree with you, then they can initiate a proceeding. If a proceeding is initiated and the defendant or his attorneys want to intervene, I'm assuming there might be a procedure, or there may be a procedure for the defendant to intervene, and then we could proceed from there. In the alternative, if either side wants me to enter an order along the lines of what Mr. Orman was just saying, given the anticipated pendency of appeals or more proceedings, whatever it may be, then either side can do that, or both sides can do that if they get together and file a joint motion for me to enter such an order, in which case you could rely on that order in denying requests that may be made. Assuming that I think that order is appropriate and I enter it. So those are the two ways that I think are appropriate for us to proceed.
That makes a lot of sense, Your Honor, and I hadn't thought about that last possibility. Here's my suggestion. If the defendant wants me not to provide this information, that they make an oral motion today and the court can order a preliminary order, and maybe give them time to file something, and I'm not saying something lengthy, so the court can do a more permanent type of thing in the near future. I don't feel comfortable trying to assert the defendant's rights to confidentiality. I don't know that I have standing to do that, so I don't want to be the one making that assertion. But I certainly think the defendant should be able to, so I think the court could enter that order, and I certainly don't have an objection to that.
Well, Ms. Brady just did, I thought, a moment ago, orally. But I still think the best way to proceed is, if you want me to enter an order, to file something in writing with specific authority and the reasons why you think an order is appropriate. And then I will take a look at whatever is filed, and then I will decide whether an order is appropriate or not. And it's probably best if you confer with each other and figure out the type of order that you both want me to enter, if you think that you both think it's appropriate. If you can't agree, then file whatever you think you need to file, and we'll go from there, okay? Thank you. Let's have everybody back at 1:45, just in case. Is that okay? Is that all right? All right, 1:45. Thank you. The court will be in recess.
All rise.